Welcome to the House Judiciary Committee this Wednesday morning, April 30th, and looking at H 511, which is a short form bill. So in order to actually take some testimony on and take a look at it, I do need a motion to take up this short form bill H 511.
So moved.
Right. And a second.
Second.
All right, all those in favor of taking up H 511, please just raise your hands. 1, 2, 3, 4, 5. Those who are opposed. No. And I don't know where, but all right, that prevails. So
I don't want to give him the satisfaction.
okay, so with that, we're going to have the sponsor of the bill kind of introduce what this is trying to solve and where this comes from. So thank you for being here, Representative Greer.
Yes, thank
You
you.
can identify yourself for the record. Proceed.
Representative Greer from Bennington. Thank you all so much for having me this morning. This is my first time in this hot seat, so I'm excited. So I'll give just some background behind more of the legal context and behind some of the things that I think, are in line or are in line with this bill. But the reason for this bill coming in so late, and I have to apologize really for putting it in so late in the legislative year, I had about 4 school board members along with their spouses that had approached me and asked what the state was doing around K through 12 education policies pertaining to ICE. They're worried that potentially ICE could come in their schools and that would disrupt the learning environment for students. So it came from a very, good place, and I thought that it would be something worth considering. I explained to them that, the committee would have to determine whether or not to take that up. So that's why it was in, short form text. But that was really the basis for it. I just felt that it should be, it should be presented. We should have some information and facts around it, and you guys can consider that. In terms of background and context, I'll just go through some data that I did over the weekend. So H 511, would require Vermont schools to adopt policies restricting the entry of federal immigration authorities into non-public areas of school buildings if they do not have a judicial warrant. Historically, the U.S. Department of Homeland Security guidelines treated schools as sensitive locations where immigration arrests were generally avoided. But of course, those protections have been recently rescinded as of January 20th, 2025, prompting state and local efforts to formally safeguard schools. And so I'm sure that we're all wondering in this committee, and I'll try my best to elaborate, what we have jurisdiction as a state over, with the federal entity. And obviously I care about, making sure we're following the law. So I won't go into the academic performance absenteeism and chronic absenteeism that's related to, immigration authorities entering schools and how that can deter families and students from going to school, can reflect on the academic performance of the students. I want to, not necessarily get into that, but I want to go and just discuss policy decisions that have made elsewhere in the country. First, California enacted Assembly Bill 699 back in 2019, which is essentially what this lays the groundwork for, is doing what they did 6 years ago. It's my understanding that it's been upheld in courts, but essentially what it does, they issued model policies declaring that immigration agents may not enter school grounds without written approval from the superintendent or a judicial warrant, among other safety guards, and schools were directed to treat campuses as safe zones for students regardless of their immigration status, and refrain from collecting immigration status information, as well as the refusal of entry to ICE agents lacking a court order. There was, I'm new to the world of ICE and immigration, I must admit, but what I thought was interesting, let me scroll down just a little bit more. So the state authority over schools in general. So of course, in Vermont, education is generally a state function. And so state law routinely mandates school policies on matters ranging from safety drills to student privacy. We govern a whole lot of aspects. And so requiring schools to bar entry to immigration agents absent a warrant falls within the state's power to govern school administration and protect students. And H 511 aligns with schools' duty to maintain a safe and non-discriminatory learning environment bolstered by the constitutional right of access to education for all children, regardless of immigration status, was recognized in prior v. Doe in 1982. So I did a little research into the court's history with this issue. So warrant protocols and staff training, I just want to highlight on this because I didn't realize the depth that ICE agents typically go to issue, I guess you would call it an intra-department order or papers. So schools and universities have different policies around this on how to verify different types of warrants, and that includes knowing about an administrative ICE warrant, which is either form I-200 or I-205. And so what this bill would essentially lay in what's been done in other states, lay the groundwork for, is that would constitute sufficient authorization because that's not a judicial warrant. So that was, just wanted to touch on that. But other than that, I don't really have too much that I want to delve into unless there's questions from the committee.
What questions?
Yes.
So I guess my first question, Will, is how many undocumented immigrants do you believe there are in the Bennington School District at this time?
Bennington School District, I wouldn't have a sufficient answer. I would say, though, in Southern Vermont, we have about, I believe, 3,500 people that are undocumented. So the number,
Students.
but yeah, and that's where I was going to go. I would believe students would be a much lower proportion of that total.
And I guess one of the questions I have is looking at the legislation that's drafted, do you have any concerns about the constitutionality?
Not off the top of my head. I'd be more than happy to explore it and hear any concerns that people have, but not on the basis of my own analysis, but I'm also not a lawyer.
Right. And nor am I, but looking at the relevant case law, and I'm talking about Hines versus Davidwitz, it, very specifically, some of the concerns is that the federal immigration law is in the federal domain, not in the state domain.
Right.
So I'm just kind of curious why you believe we have the jurisdiction to intervene.
Yeah. So I think, so first of all, I do agree that immigration, it's not even agreeing, it's just the fact that immigration is a federal power.
Right.
In terms of the jurisdiction over the schools, that's what's in question, because it is a state function, it is a state building. And so the question is that do federal agents have the ability to enter property of that nature, of sensitive nature, that's not open to the entire public? They can still go into a lobby just like any ordinary citizen, but the question is if they can enter beyond the school doors past the desk.
Yeah, I think this is I have grave concerns that this is a really severe overreach of the state's jurisdiction into the federal arena. But specific to the legislation itself, there's a really interesting phrase, and I'm curious if this is something that you crafted or if this came from the California law. But I'm on page 2, line 5. And you're now granting immunity to teachers and administrators that are intervening in federal law enforcement activity. So I'm curious if this is something that you crafted or if this is something that's borrowed from the California legislation.
So I will say that regarding the specific amendment, and please correct me if I'm wrong, when I submitted the short form, I did not get into the specific details of what your committee would decide to take up on the amendment.
But you are a sponsor, right?
Yeah.
I mean, like this is the legislation that's before us. So you're endorsing the immunity for the people that are interfering in law enforcement activity.
Yes.
Okay.
Yeah.
And is that I assume that's you're taking credit for this, or this is from California? I'm just trying to understand like what the intent is here.
Well, I'm trying to follow, no, not necessarily that it was coming from California law, nor am I trying to take credit for it.
But it's your language.
Language that I worked on, yes. Yeah.
Okay. I just want to be clear.
Yeah.
I think that's all I have for the moment, Chair.
Good morning.
Good morning.
My questions are around the previous situations that you referred to, I don't know, at Texas and somewhere else.
Oh goodness, now I'm trying to.
Do you know a documented instance of federal officers going beyond the non-public area of a school?
Not off the top of my head. I can't name a specific example, but I have heard of cases.
Without warrant is what I would first ask, and then with a warrant, and if we have any instances like that, have we read the actual after action report to find out what the circumstances? Because I just know they have a process.
Right. Yeah.
So I would like to see, I guess, a little bit more evidence on the side of your concern. And it's probably out there. I think we spoke of it before, but you don't know of any actual instance or occurrence of this happening.
Of ICE agents entering with or without a judicial warrant. I believe both have happened. I believe
Into the non-public?
into the belief so. Not in the states where this policy is currently enacted. I believe there are a few other states that have similar language.
But we don't know for sure if they got beyond that non-public area.
I would be happy to work with you guys on getting more information on that. Yeah.
I anticipate some of the other witnesses might have more information on this. Karen.
Yes, so thank you for bringing this in. I think it's really timely because Chair, my understanding is we might consider attaching this to S44.
If this is something that in the end we feel is a good policy and also legal, and so we're exploring it. But that's the vehicle where this would go if in fact it is to go proceed.
So I appreciate you bringing it. I feel like it's very timely and also being willing to come and share this. I feel like it is unfortunately a challenging and controversial topic, and it just seems very necessary during these times. And you mentioned that there were 4 school board members that brought this up. So I appreciate it as a proactive approach. I feel like let's prevent these types of situations from coming in for some of the reasons that you shared. So I'm not so much concerned with the data that's out there. I'm sure it is, but I feel like it's proactive in its approach. And I'm curious if you can share more about what those school board members and their spouses were sharing of why they wanted to see this.
So obviously, I actually do want to see more data around it. I think that's the best kind of policy decisions that we can make. And so I want to apologize to the members that it's not sufficient, that I will make sure that you have that information and work with whoever we need to get some of that. In terms of why they came to me, originally they were discussing doing it more at a local level. And I cautioned against that primarily for the fact that this is a federal and state, I guess you would say, jurisdiction call. We could frame it. And I didn't want them to potentially, and again, I wasn't advising them in a legal capacity because I don't have that power, but I wanted to make sure that they realized that they could potentially be going in an area of gray in the law where it would risk, them being sued. And I didn't want them to go down that road. So what I had said was that I'd be more than happy to bring it up at the state level. As the representative, I have to represent everyone. And they came with a pretty legitimate proposal. And so we're just working out the kinks and the issues. And so that when they approached me, it was mainly about whether they should do it from the local side or if it was something that should be broader to the state. And I said that I would caution against them doing anything that would jeopardize their status with the state or the federal.
Thinking about this more as a figure, and I wonder, I understand what your concerns about the situation may be. Having an intrusion like that. Why would we only select immigration? Why wouldn't we do the same for ATF, FBI, local law?
Well, obviously, they have very different functions when it comes to their policing powers. That's one.
They're going in for apprehension purposes.
If they're going in for apprehension purposes, specifically related to immigration statuses.
Well, why is immigration different than any of the others?
Well, I think in this particular instance, when we're talking about K through 12 schools, I think that, with immigration officers coming in, it's a very different purpose. And I want to try and make sure I'm answering your question right. It's a very different purpose that they're there versus if other federal agencies come in. And I don't really see why other federal agencies would
Well,
be in
there
there
could
unless.
be other nonviolent crimes that they could be going in there for, other agencies. And wouldn't that be just as damaging as immigration?
Yes, I would agree with that. Yeah.
So this is kind of going into the genie outside the lamp, you know, and like what I think you're starting to do here and kind of what I believe would be the dominoes effects that would impact the entire state. And one of the things that I'm extremely mindful of is the very fine line that the administration here in the state and elected officials have taken when approaching the federal government and the president and his administration in regards to immigration and a whole host of other issues. But specific to this, do you have any concerns that if this bill were passed, that federal funding to the state, like it would amplify the administration's attention to the state of Vermont, and you would be, I mean, really one of the sole proprietors of creating some really devastating impacts?
So no, I would not be afraid of that happening because I want to make sure this policy is crafted so that is not the situation. We're hoping that we can, model what's been done potentially in other places or that would fit within the frame of our laws. But no, I would not, we're not going to jeopardize federal funding, at least from my standpoint, because I don't think that that's a smart fiscal.
I think it's careful what you wish for, right? And I think piggybacking on Representative Oliver's point, looking at DHS as a broader organization, and if they were to come in and start deputizing local law enforcement agencies to operate on their behalf, how are you going to, I guess, expanding, why is this only ICE? And if DHS is coming in and they start deputizing, how do we handle that?
I think that's a broader legal discussion that we could have. I don't see that happening though. I mean, I thought that and maybe I'm mistaken, but I thought that we put in policies around not allowing that to happen, around deputizing agents, but I don't know exactly the standing on it.
I have a lot of questions about this.
Yeah, well, we have several witnesses as well who can probably answer those questions. So Angela.
Well, I just want to make sure that we're not ever saying to a sponsor of a bill that they would be the sole reason for anything. I think
Right.
that's
That's what we
inaccurate and dangerous to put that notion out there. It would have to pass a committee, pass the entire body, pass the Senate committee, the Senate, gets signed by the governor.
Right. Oh, that's true. Yeah.
An idea.
Yeah.
Thank you.
A dangerous idea.
In your opinion?
Well, and you're calling me dangerous too, Angela, so.
No, I said what you
With all due
said.
respect. With all due respect, if we're gonna get into the game of tit for tat, I think that's inappropriate. I'm simply outlining my concerns, like you have the right to do as well, and I think it's inappropriate to start calling anything that I say dangerous. I'm simply saying that there is a genie out the lamp here, that we are.
We need to.
Yeah.
A little bit more.
I know. So I think the point was,
But Chair-
as far as, saying to the sponsor of the bill that, that this one person's responsible. I think that's the point we're making.
There is one sponsor.
There's one sponsor, but that doesn't, that just gets the ball rolling. And certainly I've worked, once I saw that Will was going to do this, I started working with Will as far as language that we could look at. So, I'm as responsible for the language that's in front of us right now as Will is. So, but, I saw this as an idea. Will brought it to me. I thought it was very timely, given what's going on, given the other things that we're looking at. But nevertheless, I don't think it is appropriate to. I don't think you were attacking Will. I think, Will, you've done very well in responding to questions, but, definitely.
It was talking about unintended consequences, but I also think that I think it's also addressing unintended consequences, but I also think, and this has happened multiple times now with my colleagues across the table, of interrupting and publicly chastising me and saying that this is not appropriate and that's not appropriate. And I'm sick of it.
I guess I haven't seen it.
So if we're going to talk about decorum, then it applies to all of us. And Karen, I'm looking at you. I think it's so inappropriate. I'm sick of it. Sick and tired.
I am happy to have people point out where they feel that decorum is going awry, and Karen has done that. Ian has done that. You've just done that. Angela's done that. I think the main thing to just kind of bring this all back is that we have witnesses, we are asking them questions. We are not, sometimes we have to give some background of where we're coming from, but we're not individually testifying. We're definitely not attacking or chastising our witnesses.
Members.
Or other members. I will also, while we're going to have our next witness is going to be legislative counsel, just even in advance, I want to make very clear as far as, because from the tone or from what I'm hearing, it's fair to ask tough questions. But as far as when we have legislative counsel, they are completely nonpartisan. They're not responsible for the language as far as the intent. They do what legislators ask them to do. And I'm sure we're going to have good questions for Rick when he comes up here, but I just want to remind members that his role is to be extremely objective and nonpartisan and do the best as far as legal analysis as he can provide. I'm just saying that because there were some tough questions for Will, and you answered them fine. And some of those questions might not really be appropriate for legislative counsel. But did you have an additional question?
I do.
Yeah, go ahead, Tom.
As we spoke before, I had great concerns about, I would hate to see this happen, if
Right.
general, okay? The general. And the thought that we have to come up with a statute to prevent it also makes me very concerned, because I know even at the state level, we have at a very untested level, huge protections and standard operating procedures for going into a school. It's extraneous. Even just to go there for something simple. Now, the federal government to go and do an operation, they have to have very extensive standard operating procedures for going into a school, notifications and everything. All sorts of preemption stuff. I would like to see, and I don't, maybe you have their standard operating procedure for doing an operation that might take them to a school. Because I think it would probably prevent everything in.
And that's something that I can go look and try and look with my local law enforcement. I
I
can
mean, I
check.
see a lot of witnesses on here, but I don't really see.
Because I know in particular, I can only speak for my area, but I know that we do have, in our SOPs, we do have language around not cooperating with federal immigration authorities in certain instances. I mean, obviously, we have certain things that we do work with them on, that we want to work with them on, or we have to work with them.
The last thing immigration, I believe, in my mind, and I think you would agree that they don't want something going awry in the school when they're doing something. They don't want it to go sideways. They want to prevent having to do something within the school first and foremost. If that is the last sole area they could possibly accomplish a mission, I think there would be protocols, procedures for that. And I think that would prevent the need for a statute.
And I'll do my best to get that working.
Okay, let's go to Rick now to kind of walk us through the legal aspects of it, and then we will with this. Well,
I'm gonna say, I'm not leaving. Oh, I'm leaving.
You're leaving them?
No.
Maybe other people don't want them.
The happy. Good morning. Rick Sagal, Office of Legislative Counsel. I'm going to share my screen. I'm going to walk through the bill, and I have some examples to show you all, which may be helpful in kind of understanding what we're talking about here. So about 3-4 years ago, Vermont passed this 16 VSA 1484, which sets forth some access control and visitor policy. When people come to schools in Vermont, the assembly decided that there should be some kind of universal, access control policy that schools adopt. So current law is that each supervisory, I know you all don't deal with education a lot, I don't either. So if you have specific questions about educational law, schools, my colleague Beth St. James, she's aware of this bill, she helped me craft it. So she would be able to answer those questions. So each supervisory union board member district board, or supervisory district board shall adopt an access control and visitor management policy that at a minimum requires the following. I made a few grammatical changes here because I'm adding on a second clause, but the first clause is not changed, that they shall lock exterior doors during the school day and require that all visitors sign in at a centralized location prior to gaining access to the school or off the site. Now, current law says full access. We are striking through full because I think that may go against the new subdivision 2 coming up. The second sentence, if a school recognizes a need to leave a specific structure unlocked as needed for agricultural, recreational, or other reasonably practical purposes, it may justify leaving that structure unlocked. Okay, the new language. So the intro again is that requires the following, the policy, that no employee of a school allowed federal immigration authority, as that term is defined in Vermont's model fair and impartial policing policy, and I have that pulled up here in a second, I'll show you, access to a non-public area of a school, including a classroom, without the authority presenting a judicial warrant to the employee. That's important. I'll give you guys examples of what these warrants are and how they are different. A federal immigration detainer or other warrant or request from a federal immigration authority shall not constitute a judicial warrant. An employee that denies access to a non-public area of a school to a federal law authority because the employee in good faith believes that the authority lacks a judicial warrant shall be immune from any prosecution that may result from denial of access. The requirement to present a judicial warrant set forth in the subdivision shall not apply to an exigent circumstance unrelated to immigration enforcement. Subsection B is the same, that each school, independent school, shall adopt a written access control and policy that is consistent with the previous subsection. And then we have section 2, which is session law, that says the Agency of Education, in coordination with the Office of the Attorney General, shall develop a model policy on the regulation of visitor access to schools in the state that furthers the intent of the law I just walked you through. The agency shall consider the security and privacy of students and staff members in the development of the model policy. It shall be completed on or before December 1st, 2025, and be sent to all schools for adoption on or before December 31st, 2025. The act takes effect on passage. If I can show you some definitions, that may help. So we'll start with this is the model, fair, and impartial policing policy. So this language just applies to federal immigration authorities, which are federal agencies, departments, or employees or contractors thereof, tasked with enforcement of immigration law and border entry, including without limitation, DHS, ICE, and the Customs and Border Protection. So yeah, pretty limited in scope. We're not including other federal, ATF was mentioned, FBI. If it's related to immigration, they would be included. If it's not related to immigration, they would not be included in this requirement to show a judicial warrant. Okay. Now, a school could still require that, by the way. A school on its own could have its, I think Winooski's done it, can have its own policy that says, hey, employees, check for a judicial warrant before you enter the school. That is, there are schools around the country that do this. This law would just require them to have this policy in place. Okay, so this is the fair and impartial policing policy definition. One of the reasons I think it's important to see what these actually look like. So this is from the ICE website. This is a DHS warrant for arrest of alien. Okay, so, and you'll see the intro language here is that this also could be given through a deputized state officer, which we don't have those in Vermont. However, that's sometimes how these are done. So these, it says the word warrant, and it looks pretty official. And if you go to the bottom, it's signed by an immigration officer. So I think from a lay person's perspective, who's not a lawyer, and even if you are a lawyer, you don't do criminal defense, you see this, and okay, warrant, signed by somebody. This is, okay, this is important, I'm gonna let this person in. This is, I don't want to get in their way, right? But this is not a judicial warrant. This is a DHS administrative warrant that is signed by an authorized immigration officer. It could be a supervisor. It could be someone that is not a judge, right? Another example, so this is called an I-200, form. An I-205 is also a DHS ICE warrant of removal or deportation. So it looks, again, pretty official. You put the full name of the person and you cite what the reason for removal or deportation is. And then at the bottom, it is again signed, but not by a judge. It's signed by an immigration officer and their date and office location. I think this is the second page is specific to that person being removed. So this is also not a judicial warrant. This is an administrative warrant that is not probable cause. It is not a warrant that is been seen by a judge, approved by a judge. It is a administrative civil warrant.
It's like a notice of intent.
I would say it's more than that. I mean, it does allow a officer that is, through ICE or deputized through ICE to conduct this action. And then the person, if they believe that it's incorrect, they can challenge it, but that's later on in the process. So they would be detained because of this warrant for removal. Compare these two to legitimate warrants, arrest warrants. This is a federal United States District Court warrant. Obviously, it'd be filled in, but it's AO 442 is the typical form you see for a federal arrest warrant. It says the person's name, what the reason for arrest is, and you will see this signed by a judge. It says issue an officer signature, but it's going to be a judge if it's an arrest warrant. And more information here. So the differences are they're there. One says court, the other one does not. One is signed by a judge, one is not. But I think part of the idea here is that if you create a state policy, there's some kind of education being provided by AOE and the AG's office that say here, these are the forms that are legitimate warrants. These are the ones that are approved for federal law enforcement, immigration authorities to come in. If it's a I-200 or I-205, this is a civil warrant and they don't have probable cause to come in. It's a private area of the school. And we're talking about private areas. We're not talking about, public parts of the school where police could come in without a warrant.
Ken, what's private area of school?
Classrooms, cafeteria, probably places where students would expect privacy.
Outside of the lobby.
Yeah.
Outside.
Yeah.
Right here.
Yeah. And then lastly, you have a Vermont Superior Court, just example of a warrant, what this might look like. You would have the potentially the case name, if there is a ongoing case, the crime allegedly has been committed, and then a signature of the judge that issued the warrant, and then the officer who fulfilled the warrant. So few questions that were asked during Red Brewer's testimony. I think I might be able to help a little bit with.
Before you get to those questions, there's a couple questions I just want to ask off the bat, because when looking at this, I didn't get back to you when I saw the draft, but it did kind of raise a question, and that's on page 2, sentence on line 3 to 6, as far as immunity. That would only go to state immunity. That can't provide immunity for any kind of federal.
Correct.
Right?
That's correct.
So at a minimum, I think that if this is going to go forward on line 6, I think it should specifically spell out any state prosecution. So that was one question. The other question I had is with respect to the civil warrants. If ICE goes and presents one of those warrants that you showed me, there isn't probable cause, it is a civil warrant, but is there an action that can be brought against the person for, say, obstruction of justice, perhaps, at the federal level, if they deny the immigration officer access, because they don't have a judicial warrant as opposed to an administrative warrant?
So if they have an administrative warrant and the school employee says you don't get access, could they be prosecuted for obstructing justice? Is that the question?
Or some other federal claim?
Based on my research, no. I will double check that, but
I think it's critical.
Yeah.
it is critical. These administrative warrants do not allow police to enter private areas of a residence, a school, right? An office.
Case
building.
laws establish that.
I will confirm that, but that's, my understanding with my research so far is that the civil warrants are consent based, like you have to consent to allow them to come in to do what because it's not based on probable cause. And that's kind of we have a Fourth Amendment underlying thing here where you still have the Fourth Amendment, even though you have this administrative warrant that says this person did this thing, they should be removed or whatever it is. But you still have the Fourth Amendment be free from unreasonable searches and seizures. So if there's something else besides a civil warrant that would amount to probable cause, then you may have something else, but not just based on the warrant itself.
Do you
I'll
want to,
confirm that.
you want to go to the questions and then see which ones he hasn't answered, and then I'll go to the committee.
So a couple questions, and some of them I don't have answers to, but questions about, standard operating procedure. I think this is what the laws would do as far as access control is having some kind of standard operating procedure. There may be related to other things, but when it comes to police and what to do when an officer comes in, I don't think there is this universal statewide operating procedure. I could be wrong about that. I don't have examples of times where a federal officer has entered a school. But like I said before, this is you're really requiring a policy that is already something schools can do legally, is have some kind of like visitor policy, even if it's police. Hey, come in. We want you to show a warrant. We want you to show some kind of proof, your badge as well. Make sure you are a police officer, right? Make sure you are who you say you are. So I think I don't want this bill to seem like it's just stopping federal authority. We're aware of the separation of powers and how federal police have certain jurisdiction, but state police do too. We have the 10th Amendment, which allows state police powers as well. So my belief is that this does toe the line of what the state can do as far as regulating where federal police can go. And again, we're not stopping federal police. We're asking to provide a warrant before you go into the private areas of the school to conduct federal business. So those are kind of my answers I had scribbled as you were talking.
Question from Ian, and then I think Zach got that.
Yeah.
Go ahead, Ian, then Zach.
Private areas of schools, is that defined or should we define it more clearly in this?
Is it defined? No, but I think as it was indicated earlier that, you have the lobby of a school that's clearly public, where you check in as a visitor. I would tend to argue outside might be more of a gray area in the playground. That to me might be a little bit of a gray area. But I think once you're past that lobby, that's pretty much private.
Okay.
But maybe talk to other witnesses and see if they have, we have, I think, some school board witnesses here today that may be able to testify to in their schools what they deem to be public and private.
Okay.
Yeah.
And just a couple more. So the immunity that's proposed here is really for an employee that denies access to federal law authority, and they mistakenly do that because they don't understand that they have the correct warrant. If I understand that they can't be currently, like if your understanding is that they can't get charged with obstruction on a federal level for denial if they don't have the proper warrant to do so.
So this law obviously would not interfere, would not adjudicate federal issues at all. But the idea here is that a person, and the words in good faith does matter.
Yeah.
That means that they believed reasonably that this is not a judicial warrant and they deny access based on that, or they say, wait, let me get my supervisor here to look at this, or let me talk to our counsel that we have on retainer. That action, the intent is to prevent that person from being prosecuted under state law. Federal law, we can't control that.
Yeah.
But yeah, if it's an honest mistake, in good faith, they believe this was not a judicial warrant, the idea is to protect that person.
And then just last one for me is, so you said that schools already have this authority to create restrictions. Where does that authority come from? Is it from the statute as language exists, or is there other areas?
It's just local control. So yeah, the school board, you can look up the Winooski, as I mentioned, they did it fairly recently. I think they updated their policy to require. And it's much more lengthy than this. It's very detailed. And schools would be allowed to do that. This would be a minimum that you must have this policy that does X, Y, Z.
Yeah.
So I'm not sure if others in Vermont have, but I'm sure that some are probably thinking about it.
Yeah.
Great, thank you.
Sure.
Thank you. Thanks, Rick. And this is really helpful. And I think the examples were really welcome because it's always good to have something concrete in front of you. Piggybacking off one of Rep. Goodnow's questions is where does school authority actually end?
When it comes to,
I guess any kind of like, anytime that there's questions about federal or authority superseding school local authority,
yeah.
like how far can a school go in preventing something like this?
So are we talking about police? Are we talking about
Police.
curriculum? Are we talking about?
No, I mean,
Okay.
no, I'm not trying to be, I'm like, be serious.
Yeah.
When it comes to law enforcement interactions.
So it's state property, right? And I think I would think of it more as state versus federal, not just school versus federal.
Mhm.
Because these are school buildings that are, governed by, yes, local school board decisions, but also obviously as we're going through these education transformations here in the state, we're aware of how these things are very mixed and work together. So when it comes to police entering a school, the federal police, just like state police, have to have typically probable cause to do something, to arrest somebody, to search somebody, right? That part's not different. And I think the reason why this law is specific to federal law is because there's not a concern about state police. The concern is about the federal police doing this, either through ICE, DHS, CBP, whatever. So they're really not that different. A federal officer can conduct policing in Vermont, just like how state police can conduct their work in Vermont. But typically federal law officers focus on federal law infractions, which, students K through 12, I'm not sure how many of them are breaking federal laws on a daily basis, right? State police, state laws, you would argue a student in high school maybe did something wrong. It's, broke into a store, whatever, stole something. That would be seemingly more of a relevant thing for state police to do. So I guess my answer is that there is a line, but I don't know exactly how to define that for you and tell you, yes, this is clearly state police. Yes, this is clearly it's shared.
Sure. And I guess the kind of the crux of the question that I'm trying to get at is, if you have a Vermont junior, senior, who's here illegally, and they are breaking the law by being in the country, without a green card, their parents are not residents, or American citizens. I think that my suspicion is that would fall in the federal realm. That this is no longer a state law that they're breaking, it's a federal law.
You're totally right. So it is a federal law.
And
but
the authority does not go that far.
but also remember, immigration is complicated. So you're here, you're not really breaking a criminal law if you are here without documents. You are here without documents, right? And traditionally, that person would be removed or deported if they are found out or if they break some other criminal law, right? That makes them subject to deportation. I think the concern now is that people are being targeted without having broken this underlying criminal law, right? And because they're here without documents, they could be subject to removal. And so I want to make that clear as well, is that usually there's this underlying, they did something bad. And now they're in the system. Oh, hey, you're not here with documents. So now you're subject to removal, right? So I think that's what this is trying to address.
Sure. And so a follow-up question is, on the warrants that you outlined from DHS in the term immigration officer, is there ever an instance where an immigration officer is not an employee of DHS?
I can't answer that for you. I don't know.
Yeah, I'm just asking that question.
I don't know. I would assume that they would be, but
Yeah,
yeah.
I would assume, but this is a whole new world. Getting to the, I think one of the topics that's come up from a few different representatives on this is the non-public areas of schools. And so, I think we all want to assume, right, that schools are, and administrators are good actors. But say in this instance that you have a bad actor and you have someone who is, protecting and is welcoming undocumented immigrants, adults, not children, not students in the school. But say a school says, you know what, come here, and this is a safe haven. I think it's a legitimate question because the term student is not introduced in this until you get to section 2, line 16. So I'm just kind of curious, like if the intent goes beyond students and schools could be used as safe havens for undocumented immigrants.
So the question is, could a school harbor people who are not students or staff in like the gym or something, right? And keep them there away from federal authorities? Yes. Under this law, if the feds would still need a judicial warrant to enter the school.
Sure.
So yes.
But this would allow for that.
Sure.
Yeah.
Yeah.
So, and then there's one other I had. In public. Yeah. So line 8, page 2, exigent circumstances. Can you just, I know that's a term that we use in this room often, but can you just explain what that might mean in this instance?
Sure. So this line was meant to make clear that federal authorities come into a school for some kind of emergency, school shooting, something, right? Horrible's happened, that the employees don't ask for a warrant, that they're allowed to come in. It's unrelated to immigration enforcement, but there's something. It could be a fire, it could be a shooting, it could be, reports of a kidnapping. I don't know, right? Something unrelated to immigration would be allowable without showing a warrant.
So what if a school administrator called ICE and said, we have reason to believe that there's undocumented immigrants that are here illegally, they're guilty of a crime? Would that qualify as an exigent circumstance?
I don't think so.
Okay.
Yeah, unless the crime is ongoing. If there's a crime happening at the time, like active crime, right?
Well, that's what I'm saying. Yeah, like say there's inactive violence in the school, that would allow ICE to come in.
Right. Like happening at the moment, yes.
Yeah.
This is like, we have to come in to stop this.
But now if we believe I'm just saying like a murderer from Brazil is in the school and the crime has already happened, we know for a fact that this is the person, and we're calling saying like, help, we believe students are in imminent danger.
You're really pushing the exam thinking. Yes.
I mean, like, that's what this the whole process is for.
Exigent, is a term of art, and typically it is, there's probable cause to come in, and this is like, if we don't act now, it's going to get bad.
Right. And you could kill again. Right.
Right. I would not consider that exigent, but but they could get a warrant. They can get a warrant.
Sure.
Right.
No,
right.
Sure.
Right.
Angela.
Rick, thanks for being here. Can you talk to us a little bit about the difference between school policies and state law? I know that may sound like an obvious question, but I'm just, looking at the policy for our district, and this did come up in our district when I was still on the school board, and our policy itself is one sentence. It's very simple and very broad, and just says that it's the policy of the school district to provide a safe environment for students and employees while facilitating access to school buildings, premises, and equipment by authorized users. It's actually 2 sentences. The safety and security of the district's physical space and assets is a shared responsibility of all members of the district.
Yeah.
There's nothing in there really. And then it gives the responsibility to the administration, superintendent, or designee to develop procedures. So often school boards and school districts deal with the very important distinction between policy and procedure. Boards don't set procedures. So can you talk to us a little bit about the difference between school policy, state law, and perhaps what I perceive as the importance, I comment on, if you wish, the importance of a state law to perhaps either, overlay or undergird school policies?
So I can speak to the state law versus school policy, right? So state law would supersede any school policy that is set. And this law is intended to require schools to adopt a policy that at least meets the standard, right? They could go further. They could say, they would need to be careful. They would need to be counseled by their own lawyers about how far they can go. But if this law were to pass and be signed by the governor, and a school decides to not require judicial warrants, they would be in violation of the law, of the state law, right? If a school decides to increase their access policy, be more limiting in whatever way they wanted to be, they would not be against state law. They could be interfering with federal law, right? When it comes to immigration enforcement, but they would not be going against the law that we've set, if that makes sense. As far as school board versus, that I would defer to my colleague Beth St. James, who knows more about that governance structure than I do. But I hope that helps as far as, the state can set the bar at a certain way, and that's what this would do. And the schools would have to at least meet that bar.
And so in your view, would the school policy need to contain the information about the specifics about the warrant, the need for a warrant?
Yes.
That would
Yeah, because subsection B, which is already law, right? That each school would have to adopt a written policy that is consistent with the requirements. And then the session law, where the AOE and the AG's office would have to help, kind of write out this probably much more comprehensive model policy that doesn't exist, right, by the way, for this locking the doors, which seems pretty easy, but I think this might be a good idea anyway, to have AOE involved and the AG's office involved in this model policy that would be more than one sentence. It would be somewhat more comprehensive, I would hope. Yeah.
Question for Rick? Tom?
Just to get back to, do you think it was bad to expose, front of the house, employees to making these decisions when they happen? I can see so many different scenarios happening in my mind that could really go bad if they were just doing it based on a policy we handed them without, their lawyers getting involved or the principal making decisions well versed on what actions to take.
Yeah, I think as you said, it's not great, right? Police coming to a school is already not great. It's a tough situation. And these things could be happening now, and they are happening across the country to some extent, right? So I think just that happening with or without this law is troublesome, right? How schools today would handle that situation, I don't know. Each school will be different. Some may have a staff member that's trained on what these warrants are and which ones are civil, which ones are criminal. I imagine most don't. And I imagine most don't have a contact person that is like the point person, like, hey, this Jim here, Jim's our guy. Police show up, talk to Jim or Shelly, whoever. That might be, I want to be fair. That might be something that the model policy would have, is you have a one contact person at each school that is trained, maybe does training every year, that learns what these warrants look like. So I guess to answer your question, right, I agree with you that this is not great, but I don't think this law would make it worse than it may be today if this law did not take effect.
No, I don't think it would absolutely make it worse, no.
Yeah.
And I think folks try to mitigate this before it becomes an issue. Generally, sure, it's the right thing to do. Take a phone call, hey, we're coming down.
And that's a good question for one of the later witnesses. We have the attorney for the Vermont School Board Insurance Trust who will be testifying as well. So, good question. That's why I want to make it. Anything else for Rick? Yeah, Barbara.
And I came late, so I don't know if this got covered or not, but one thing I was thinking about as a social worker and my concern for trauma in schools, I know that there have been law enforcement who have been wearing masks recently when they have done, when they have come to get somebody. And I'm wondering if addressing that issue, that's incredibly scary for kids if somebody's coming in and they're masked. So I'm wondering if how that.
Yeah. So my colleague Tim Devlin is here, and he can talk about state, officer dress. But when it comes to federal, there's nothing that the state could do. Federal police, have their own guidelines, and you could say federal law enforcement must or all law enforcement must not hide their faces, however you word that, right? but it wouldn't be effective against them. And Tim, do you want to speak to the state police?
Sure. In current state law, there are sparse requirements for identification of police officers, whether that be face, name, badge number, anything like that. It's really found in the state law enforcement agency guidelines, if there is any.
And a school policy couldn't address it with federal.
Tim, if you just identify yourself.
Oh, I apologize. For the record, Tim Devlin, legislative council.
So if you had like a visitor policy that said you must not wear a mask.
And I'm not talking about like a mask for.
Yeah. Like a ski mask.
The shoes.
Right.
But right, like just again, like frightening children.
You could come up with that policy and schools could adopt it, but then once federal police come in, they're not going to be subject to the school policy, right? If they have a warrant, especially with a warrant. Yeah.
Even in the lobby. I think that's.
I'm a law enforcement, did you their faith?
Not a question I can answer.
Do you know?
Why would? No,
Okay, anything else? Do we want to break now or do we want to hear from Falco first when we have a break? Can you, Mike, break person?